Mr. Counsel, before we go any further, I just wanted to pick up a point we were discussing earlier this morning. You may recall we had that discussion about whether the obligation disappears after whatever the date is that is reasonably practical. And I did mention there was some other authority which is relevant to that. There are three cases, I think. One is called Therium, Therium, and Brook with an E, 2016 EWHC 2421. There's another one called KS Energy Services and BR Energy, which is 2014 Building Law Reports, page 658. And the third one is called Astor Management and Atalaya, 2017 Business Law Reports 1634. So I'm sorry to add to your travails, but it might be worth having a look.
Of course I will. Would your Lordship give me perhaps overnight to do that?
Of course.
Thank you. Can I pick up on another question which your Lordship asked, which I wasn't able to answer without giving it some thought, and that was what to do if you were to think that the judge either didn't need to or should not have made a finding in respect of the Hawali payments.
Yes.
To which our answer is reduced or different sanction. And I say that for this reason. The Hawali payments related to counts 3 and 9, so the AET and the soft code counts. And if your Lordship turns, those are the ones where the judge determined that because of that aggravating feature, namely deliberate misleading, the sentence should effectively be longer, although I appreciate that there's a totality argument and all of that. If your Lordship turns to Core Bundle, page 256, right at the end of the sanctions judgment, you'll find at paragraph 24 and the subsequent paragraphs how he broke it down, although I stress that it's wasn't, of course, simply a case of breaking it down and then adding them all up. In paragraph 24, he deals with ground 2, first of all.
Yes.
At least 9 months. Ground 3, which is one of the two, at least a 9-month to 12-month sentence. And then 4 and 8 were 3 months. And then 9, the other one, a serious breach, which again involves serious misleading, would attract at least a 9 to 12-month sentence. So the two where he considered would attract the most lengthy sentences were in fact 3 and 9. And the reason that he did was largely because of his view about the Hawali payments. So our submission would be either that the sentence should be reduced. Now, of course, it may be said that ground 2, he identified a sentence of at least 9 months, or if he took the view, if he ought to have taken the view that the sentence was considerably reduced, then he ought to have been considering a suspended sentence and so forth. That's the way we would invite your Lordship to deal with that point. Now, can I then turn to the remaining grounds, 8 to 11, which relate to sanction? First of all, we submit that the judge applied the wrong test to the issue of whether the sentence ought to be suspended. And the first point to make is the judge's observation during the course of submissions on the second last day, so the 5th of March, the day when we came back and the judge was persuaded to adjourn for 24 hours. That a suspended sentence was, to use his words, no sentence. That appears in the supplementary bundle at tab 20. And I just invite your Lordship to turn to it.
But the context in which he made that remark was on the question of whether there were to be conditions attached to the suspension such that it could be activated in the future.
Yeah, the sort of damage.
I asked you about conditions and you weren't suggesting any. And it was in that context he said, well, if I can't activate it, or at least if I can only activate it in unpredictable and unforeseeable events, what is that in terms of sentence?
Well, I have to say I'm slightly flummoxed by that point because I'm not aware that suspended sentences usually have conditions imposed upon them. The defendant in criminal proceedings is warned, if you commit a further offence, then you're in danger of the sentence being activated. And the answer to that question, perhaps this is something that I should have said, was that if he committed another contempt, then the sentence could be activated. And that's the threat, the sword of Damocles threat. Now, this is a case, of course, where this appellant is facing lengthy proceedings. I certainly don't want to invite any particular approach, but the fact of the matter is that it is just the sort of case where there may be applications. And if there were to be a breach, if there were to be a contempt, then it could be activated. And the proper approach would it be for the judge, if he was correct to determine that it should be suspended, was to make it absolutely clear to this appellant what would lead to, what would happen if there was a further contempt. Now, I accept that may not be the same as the criminal defendant who faces a prison sentence or an additional prison sentence if he commits a further offence, but that's the event of my submission.
Yeah.
And we've referred in our skeleton argument to the case of Wilkinson, which is where Lady Justice.
But if you go to the supplementary bundle, page 786, which is where you and the judge are having this discussion.
Yes.
What the judge says at manuscript page 32, line 19, is if there are no conditions attached, then suspending in those circumstances is the same as not imposing one at all, because it is hard to see how it could ever be invoked. And you say it's a sentence of imprisonment, not to be served immediately. The judge says it's pointless. And I think then at page 33, 4 to 7 is where you make the point that if there's another contempt, then it could be activated.
Well, yes, I'm not sure I even put it that way. Perhaps I should have done, but I actually referred to the possibility of committing offences, which I don't think is right. Committed further.
Oh, yes.
No, I don't.
Yes,
I don't get it that wrong.
But translated into this case, you say if there were further contempts of court, not just breaches of order, but contempts of court.
Yeah. Yeah, I do. There's another point at all which makes it not no sentence, which is that it's a sentence of imprisonment. And to a man who was a good character, with his background, not for anybody, but particularly in this case, a sentence of imprisonment is a serious sanction. It by no means can be suggested that it's no sentence at all. And perhaps that's partly reflected in my learned friend's response, which is, well, he didn't really say that, but we'll hear from a learned friend about that.
Yeah.
If the judge had approached the matter correctly, we say, he would have suspended the sentence. I'm sure I need to take your lordship to the authorities, but a custodial sentence, either in the criminal jurisdiction or this one, is a matter of last resort, and particularly in civil contempt cases, where the principal aim is to secure compliance and not punishment. In this case, of course, the judge was clear, and I'm not going to deal with this now. It's a matter for response to the cross appeal if we get that. That the purpose of the sentence here was punitive only.
Well, I know it's a response to the cross appeal, but it has a bearing, or at least it may have a bearing, on whether the sentence should have been suspended. Because if there was a coercive element, the judge said there was not, although I think in his main judgment he thought that not all had been revealed even now.
Yeah, he did. I think he took the view, essentially, that there was no point in including a coercive element. But that, whether or not there was a coercive element, doesn't, in my submission, affect the point that he's got to approach it on the basis, is this a case which can be suspended? And of course, I did say whatever be the rights and wrongs at that point, whether there should have been a coercive element or not, and we say in fact there shouldn't. The authorities suggests that that is something the judge can do but isn't obliged to. The first thing to do is to consider whether to suspend it.
Yeah. So you say even if there is no coercive element,
Yeah.
the judge should still have suspended.
Yeah, I do. And the other factor is that suspension may be appropriate where immediate imprisonment would have a serious effect on others.
Yes.
And the one big point, of course, in mitigation was the need for help with his mother's care.
Yeah.
And
that caused the judge to reduce the sentence
It
by
did.
6 months.
it did, and I accept that. But we submit that wasn't the way he should have dealt with it. He should have dealt with it by suspending. And we rely on those two cases which he set out in paragraphs 101 and 102. First of all, Kawaja, where the court was prepared to suspend an 8-month sentence in a case where the contemner's caring responsibilities for her young child made that an appropriate sentence, and the harm that that would cause to her daughter if her mother were incarcerated. And the second one, perhaps more similar, although except, of course, that the case is different, is Templeton,
Yes.
which is the case where, your lordship will be familiar with the case, the trial judge had imposed a sentence of immediate imprisonment, and the Court of Appeal substituted a suspended sentence in a case where the contemnor had become the sole carer for his wife, who was suffering from spina bifida.
Yeah.
And I do say this case had very similar features to that. Your lordship will have read the difficulties so far as Mr. Turk's mother is concerned. Number of very serious medical conditions, completely dependent upon the care which her husband and his son provide, and there are witness statements to that effect. And in circumstances where, because of her religious beliefs, it was very difficult indeed, if not impossible, for someone outside the family to provide that care. And finally, and it's not a make-weight in isolation, it's an important factor, which is the public interest in ensuring that the prison system remains functional and that the prison system is dealing with the most serious offenders. He failed to take account of the sentencing guidelines in respect of that and the desirability of keeping offenders, particularly first-time offenders, out of prison. Now, that submission, of course, has more force if the lordship were persuaded that this sentence was too long, because, of course, a contemner who may be the subject perhaps of a 3-month sentence, it's a more compelling argument to say that in those circumstances, the judge should seriously consider whether the sentence at all is appropriate. So then I turn to the next ground, which is the taking into account of aggravating and mitigating factors relevant to the severity of the contempt. We do say that first of all, the judge failed to take into account the steps taken by the appellant to comply with the order. And secondly, this is not a case of a contemnor who had shown a complete disregard for other court orders or hearings in these proceedings. Quite the opposite, in fact. Minor point, but he didn't take any objection to the terms of the Miles order at the return hearing. He appeared at that hearing when no other defendant attended. He did make, albeit limited admissions to breaches. And prior to that first hearing, he offered through his counsel to answer any questions which the respondent might like to list, an offer which was quite properly declined by my learned friend on the basis that he doesn't need the claimant to walk him through his obligations. Well, in the context of the advice that he was receiving at that point, that's in my submission, an unintentional
I think it's
error.
difficult for you to say the judge took no account of it. He did take account of it, but he rejected the points at
Yes, he did.
C to F
He did.
of paragraph 16.
He did, and well, your lordship has the point. For the reasons which he gives, he rejected them, and he also rejected points of mitigation such as which he suggested at one point that the admissions that were made, or the statement that was provided very late in the day. With respect, he was doing no more than exercising his rights not to elect to rely upon a witness statement, let alone give evidence, until late in the day. That is his right, and to effectively to hold it against him, a decision upon which he received advice, is, in my submission, unfair. He also it's really paragraph 107 of our skeleton. There's a distinction in our submission to be drawn between aggravating conduct, which can't be argued was attributable to the applicant, to the appellant personally, and conduct which was, to use the example I've just given, in the lawful exercise of his rights, or fell within the advice and expertise that he was receiving from his legal representatives. For example, whether or not to make a submission in no case to answer, because, for example, of what we say is a defective penal notice. He really can't be. He can't use that as an aggravating feature in my submission.
Well, is that what the judge is doing? Is he saying it's an aggravating feature? I think all he's doing is saying it's not a mitigating feature.
So I could.
Page 254 of the bundle, C. This is all on, in support of his point, there was no early admission.
Yes.
And he says Mr. Turk's witness statement, which accepted shortcomings, only came in formally when you elected to put it in. So he's not, I don't think, treating it as an aggravating factor. He's saying it isn't a mitigating factor.
Yes. Not entirely clear from the stem of paragraph 16 whether he was dealing with it as aggravating or mitigating. Although, well, he does say I put mitigation or clemency to one side for the moment. So it does seem that he's dealing with aggravating features. Next, personal mitigation. We do say the judge, I've said it already, failed to give adequate weight to what was clearly exceptional personal mitigation in this case, the extensive caring needs of his mother, and the risk of a serious deterioration. The evidence that his lordship had was that not only was there concern that he wouldn't be about to help her, but also that it might lead to a serious deterioration in her condition, which apparently had happened on a previous occasion when he wasn't around, or when something had happened to her. If the judge had given proper weight to that personal mitigation, in particular the impact on the appellant's mother, he would have suspended the sentence. And this is an appellant, of course, a contemnor, who was of good character, whose career had been effectively destroyed by what had happened. I can't say other than he has himself to blame for that, but that is the fact of the matter. And whose health has been affected, and who the prospect of sending him to prison would have a serious effect upon his children, who he spends a lot of time every day with. A lot of time remotely. Yes, I think the evidence was that he would FaceTime them for about an hour and a half a day. Yeah. We say, therefore, finally, last ground, the sentence was manifestly excessive. fact, culpability and harm could not be ascertained, certainly harm could not be ascertained, was not properly taken into account, and I've addressed your lordship on that. He should have taken into account, or did not adequately take into account, the appellant's good character, and also his remorse. He's repeated an early apologies. He did in his witness statement, I think it's paragraph 6 to 9, in the witness statement which was served as part of the sanction hearing, make clear. Can I take your lordship to it, in fact? It's in the supplemental bundle, and it's at page 800 in tab 22. Page 801.
Yeah.
He says this, and your lordship will be aware.
Yes, I've read it.
You've read it, thank you. Yeah. Mr. Turk had little time to gather his thoughts and to put this together, and we submit that the judge didn't adequately take that into account. And finally,
I mean, he did take it into account.
he did mention it.
In 16E.
Yes, he does. He does mention remorse, but not adequately. And finally, I've said it already, the devastating impact on him and others, but him in terms of the deterioration in his mental health, loss of his career, and the pressures on his family as a result of the sentence. In all the circumstances, we submit that the judge should not have imposed an immediate sentence of imprisonment, should have suspended it. But even if that were the correct sanction, then the term for a first-time contemnor should have been less than it was.
Yeah.
Those are my submissions.
Can I just ask you one point,
Yes.
Mr. Counsel?
Of course.
What, if anything, do you say about the point that Mr. Turk makes in paragraph 33 of his witness statement, supplementary bundle, page 805, about the effect on the ongoing proceedings of being committed to prison? Which I don't think the judge mentions.
No, I am. He did mention it, in fact, once when we were dealing with whether there should be an adjournment or not, because his concern was how, or no, whether or not he should proceed immediately to sanction, because there was a discussion then, which I think involved the tipstaffs as to how likely it was that instructions were going to be able to be taken. But I don't think he does deal with that. In my submission, it is a factor. Of course, Mr. Turk was not represented, but it would inevitably have made it more difficult to try to defend himself within the underlying proceedings if he were in prison. Yeah. And your lordship makes a good point that I don't think he deals with that specifically. Thank you very much.
Thank you. Yes, Mr. McCall, Fritz.
My lords, my lady, in our submission,
Just let me clear away a few bundles. Yeah.
in our submission, all of the grounds of appeal put forward by Mr. Turk can and should be rejected summarily, with the result that the appeal falls to be dismissed. That is because each and every one of the grounds suffers from at least one of the following 4 fatal defects. First, constituting a challenge to an unassailable factual finding. Second, constituting a challenge to an unimpeachable exercise of discretion. Third, being rendered futile or academic by reason of an unassailable factual finding or unimpeachable exercise of discretion. And fourth, being based upon a misreading or mischaracterization of the judgments below, and in some cases, ignoring reality, most notably in respect of ground 4. In an exchange with Mr. Counsel, my Lord Justice Lewison drew attention to the judge's finding at paragraph 280 of his liability judgment that Mr. Turk was himself capable of understanding the order and what it required. That was a finding of primary fact based on the material before the judge, and in particular based on the 3 days of oral testimony from Mr. Turk that the judge heard, for which there is no substitute. It is not an inference, as my learned friends sought to suggest. It is a primary finding of fact. It is unimpeachable.
Slightly ironic in view of your complaint, the judge himself misunderstood the order.
Well, my lord, I anticipated that point. I was surprised in a way Mr. Counsel didn't make it. But the misunderstanding of the order is very narrow and discreet on our cross appeal, as you will have seen. And as I submitted before Sir Anthony Mann, on a proper analysis, there is no complexity in this order. This is what Lord Justice Nugent described in Kia as tracing relief. It's disclosure necessary to give effect to a proprietary injunction. The complexity comes in because of the way Mr. Turk dealt with Miss İŞBILEN's assets. So they're sent to the four winds. He uses a whole web of structures, complex series of payments. And that's where the complexity comes in. And it's in relation to, as I say, a very discrete point that the judge fell into error in his analysis of the obligations. It's solely in saying, this is to foreshadow my cross appeal if I'm granted permission to pursue it, it's solely in saying the money trail stops when a payment's made to a company that the respondent controls, even if the respondent knows what that company then did with the money. We say that's just wrong, especially when you apply what the judge correctly held is the relevant test, which is whether Mrs. İŞBILEN had a seriously arguable proprietary claim to the relevant asset. And we say, if you take Bethlehem, if as is true on our case, Mr. Turk unlawfully induced Mrs. İŞBILEN to transfer money, purportedly by way of share purchase of shares in his company, and then used the money that he'd obtained from her to buy a yogurt factory, he does not discharge his obligation by saying, you bought shares. He needs to say, with the money I got from you, I bought a yogurt factory. But that's a point of detail, and I only go there now in response to my Lord's question. It's a very discrete point that the cross appeal raises. In all other respects, the judge construed the order correctly. And there's no irony in the judge's finding that Mr. Turk, understood the obligations that he was under. And no irony at all in the subsequent factual finding, again unimpeachable, that Mr. Turk simply did not embark on the exercise that he knew he had to embark on. It's that finding that forms a critical, contextual background for everything that my learned friend said. And it shows so much of what he said to be unreal, because Mr. Turk, on the judge's findings, knew what he had to do and chose not even to try. That unreality is further reinforced by other aspects of the judge's factual findings, which are not challenged, could not be challenged. The judge said at paragraph 155 that Mr. Turk was an expert banker, late of Goldman Sachs, seeking to set up his own bank, who accepted responsibilities for managing tens of millions of dollars of Mrs. İŞBILEN's money, and as I say, dealt with it in notably complex ways across a range of jurisdictions. He purported to set up a Cayman Islands fund in which Mrs. İŞBILEN was the sole investor. He was not a naive man, and he showed himself in his professional endeavors to be far more capable than those representing him before this court now seek to suggest. The judge was perfectly entitled to have regard to all of those matters, as he plainly did. Staying in the liability judgment, at paragraph 267, which is on page 225, I'm working electronically, but I see all three, my lord, my lady, working from paper copy. So tab 11 of the core bundle, page 225.
Thank you.
At paragraph 267, it is really the bottom of that paragraph that I'd invite you to read, and then I'll make some submissions about it if I may.
Starting, however, having seen how Mr. Turk conducts himself in the witness box, that bit.
My lord, yes.
Yeah.
And you've been shown it before, but obviously without my having the opportunity to emphasise anything arising from it. The judge formed the view that he was intelligent, he obviously is, and capable of understanding the sort of thing that he had to do. That assessment is preeminently a matter for what was in effect the trial judge. I'm going to refer to him as the trial judge. I know he was hearing a committal application rather than a trial properly so called, but it's preeminently a matter for him. It's not a matter for expert evidence, how the witness appears to understand questions. And we obviously don't have time to go through the transcript line by line, but the answers that Mr. Turk gave make abundantly clear his level of comprehension. That level of comprehension is reinforced by the almost complete absence of intervention by the intermediary. So Mr. Counsel explained part of what the intermediary did, but my Lord Justice Lewison, rightly in my submission, took him through highlights of the ground rules hearing. The ground rules hearing led to special measures being put in place. That's why ground 4 can just be dismissed out of hand. It's put so high as no special measures were put in place. Well, they were. Special measures which the intermediary, who is the expert, approved were put in place and adhered to, with some exceptions. But it's impermissible in my submission for a respondent to committal application not to object at the time and then to bring an appeal on procedural fairness grounds, a fortiori, where there's an intermediary sitting there who's not objecting.
Yeah. I mean, in a sense, that ground comes first, because if the trial was unfair, then the whole thing's got to be set aside, whatever the rights and wrongs of all the other grounds.
My lord, yes, it categorically was not unfair. The judge, in informal terms, bent over backwards to facilitate Mr. Turk's needs. As he said in the judgment, the ground rules hearing took place when it did because the point was taken so late by Mr. Turk. It wasn't anyone else's fault but Mr. Turk's that the ground rules hearing didn't come earlier. The ground rules hearing happened. I then had to meet with the intermediary to be coached on how to cross-examine someone with ADHD. I took my coaching. Ms. Stewart never suggested that I had fallen foul of it. So she was there to check. The judge was there to check. Mr. Counsel was there to check. There was no unfairness. And that ground should, in my submission, not have been advanced. A further reason for that is that Mr. Counsel, in showing you the intermediary's report, rather glossed over the expert report that Mr. Turk filed at the time that he filed his responsive evidence.
This is Dr. Gupta.
Dr. Gupta, in the supplemental bundle.
Yeah, well, his main recommendation was appoint an intermediary.
Well, that was the recommendation, but I wasn't going to mention that so much as, because obviously that recommendation was implemented, my lord. Dr. Gupta said it's as well to show you rather than to paraphrase how limited Mr. Turk's issues were, if I can put it that way. So supplemental bundle tab 6, page 164.
Yeah.
It's to show you this. I could, if it would assist the court, show you other parts of it. But Dr. Gupta's evidence we positively relied on as supporting our case. And again, with an air of unreality, Mr. Turk ignored it, because Dr. Gupta says there, first of all, Mr. Turk informed me that he breached the order, as the details of the matter were not mentioned on the first page, and he had not read the entire document. So that's what Mr. Turk apparently told Dr. Gupta, although in fairness to Mr. Turk, when I cross-examined him, he said, no, Dr. Gupta had got that wrong. And then Mr. Turk said he'd read the order several times. And then Dr. Gupta says, as mentioned in my report above, Mr. Turk struggles to concentrate for long, note, and earlier in his report, Dr. Gupta explains that Mr. Turk has a tendency to lapse into short bouts of inattentiveness. So his default state is attentive and comprehending. And then he has a tendency to lapse into short bouts of inattention. That's the true position according to Dr. Gupta. And importantly, I emphasize still in this extract, the words, he has the ability to comprehend the order and engage in the proceedings. So the judge's unimpeachable factual finding that Mr. Turk had the ability to understand the order is reinforced by Mr. Turk's medical evidence.
Yeah.
And so the procedural fairness ground was presented in two overlapping but distinct ways. The hearing was procedurally unfair, and it was hinted that it was something procedurally unfair in seeking to commit someone who had ADHD for breach of this kind of order because they were so incapable of understanding it or doing what they had to do. Well, Dr. Gupta's report completely explodes the latter limb, and the former limb ignores reality. And as regards the adjournment application, as in the adjournment application during the course of Mr. Turk's evidence, if my lords, my lady haven't yet understood the circumstances in which the need for that arose, it's explained in Sir Anthony Mann's judgment granting the adjournment. The adjournment was opposed by Mr. Turk. So we're in the curious position where Mr. Turk said he'd waived privilege and said he wanted the court to have all the relevant information before it, but then opposed my application for disclosure of all the relevant information and for time to let me and those to my side and behind me to process that information. So he said, all the cards on the table, but you can't have those cards. And the judge held it was his fault. It was his fault that and the fault of those acting for him, that the waiver had not been done earlier, that Bavonus had not been pursued with greater diligence and clarity, and that those representing him had not themselves been clearer about what they had and what they'd asked for. So it was all the fault of Mr. Turk and those acting for him. That was so the judge held in granting the adjournment. And set against that was the suggestion from the original intermediary that an adjournment would be upsetting for Mr. Turk, not because of his ADHD, but because of his anxiety. And the judge exercised his discretion in a way that I would suggest is unimpeachable in granting the adjournment. I would have appealed if he hadn't, but they didn't appeal. And they would have needed to, because that was an interlocutory decision that they could only have appealed with the permission of either the judge or this court. So there's no procedural unfairness. I'll return to ground four to the extent that my lords, my lady need me to in due course, if I might. I was still surveying the ground, if I can put it that way. And in doing so, I wanted to deal with various questions that fell from the bench. Next was my lady, Lady Justice Lang's question about the evidential burden. Where a respondent to a committal application raises as a defence the contention that they did not understand what they had to do, which properly analysed goes only to seriousness of contempt, not to the question of liability. And because you do not need to understand an obligation to be in contemptuous breach of it. It's just that if you could show that you did not understand the obligation, it would be unlikely to be punishable by way of committal. And my Lord Justice Lewison indicated a lack of fondness for the term contumacious. So I'm going to use instead, I think it may be my own term, committable, because a committable contempt is distinct from a mere contempt. A committable contempt is a contempt that is properly punishable by way of committal, as distinct from what's described in Sectorguard, for example, as a technical contempt. And a technical contempt could be made out where the respondent ticks all the Masry boxes, if I can put it that way, but does not understand the obligation or has some other excuse for their breach. But returning to my Lady Justice Lang's question, where such a defence is run, the evidential burden is assumed by the respondent. It has to be, because the respondent's understanding is uniquely in their ken. And so the question for the judge was, had Mr. Turk discharged that evidential burden? And he obviously didn't. And to the extent that it will assist the court, I'll explain why the judge was so manifestly entitled to come to the factual findings that he did.
So you accept, do you, that there is no legal burden on the respondent to prove that he wasn't properly advised? There is an evidential burden.
It's an evidential burden, my lord, because the legal
burden remains with the applicant throughout.
Well, my lord, one needs to tread carefully there because of the earlier submission I made about it goes only to seriousness, not to liability. So it's my burden to prove contempt.
Yes.
But his understanding of the order doesn't come into that. And then, if I want to persuade the court that a committal order is appropriate, I need to show the court that it's sufficiently serious. In response, Mr. Turk, in my submission, misguidedly sought to rely on his purported lack of understanding as a defence on liability. I say that's just wrong in law. If you're against me on that, then that might be conceived as his assuming a legal burden. But I am solely focused on my analysis, which involves it being raised as a defence to sanction, really, a defence to seriousness, where the legal burden remains on me to prove seriousness. But if he wants his purported lack of understanding to be given any weight at all, he needs to discharge the evidential burden.
Yes. I mean, if you had a Newton hearing, this burden would still be on the prosecution to prove their version of facts.
But my version of the facts is he understood the order. The judge accepted that, as I've already shown you. His response was, I did not understand the order. Well, actually, his response evolved tellingly over time. I'm not sure that we need get into this again unless the court indicates it would assist to do so. But in his witness statement, his careful statements that he didn't recall being advised turned into, in the witness box and in submissions, he was misadvised or he was not properly advised. So a positive assertion of a lack of advice. Our point throughout was, and here is a true irony, well, if you're going to try and run that argument, you need to waive privilege unqualifiedly and now, which he did not do until he elected to rely on his witness statement, which was during the committal hearing.
I mean, the strongest piece of evidence in his favour is Mr. Shepherd's email.
Well, my lord, in his favour, in one limited sense, and I can deal with all of the reasons why it's a limited sense now, if it would assist.
Right, I don't want to take you out.
Well, it's important to understand at least where I'm going, my lord, because Mr. Counsel sought to say that because it was a forthwith obligation, we needed somehow to prove understanding by the 18th of March, or possibly before the 18th of March, although I don't really follow that. The judge found that there was understanding by the 18th of March. And I'll come to look at the judgment in that regard. So the judge found knowledge by the 18th of March. And my lord, I agree that the email from Mr. Shepherd is evidence that goes in the balance in favour of the conclusion that before the 18th of March hearing, Mr. Turk may not have been fully advised or may not have understood his advice. Another point my Lady Justice Elisabeth Laing made. It's Mr. Shepherd's impression of Mr. Turk's understanding, which is itself based on an inference as to the advice that Mr. Turk received. But yes, it's weak evidence that perhaps Mr. Turk wasn't advised as well as he might have been. There are a number of important factors that go in the balance on the other side as to Mr. Turk's understanding, including in particular the letter that the order was served under cover of.
I don't think we've got that, have we?
It's not in the bundle, I don't think, my lord, but we can certainly
No.
produce a copy if that would assist. There was, I've got copies to hand up if that would assist the court.
Was it before the judge below?
It was. Well, and he referred to it and relied on it, my lord. So he said he approved it as explaining the terms
Yes,
of the order
this
did,
one
he
he
did.
said was readily comprehensible and appropriately accurate.
by this expert banker who was very sophisticated, who again the evidence before the judge showed had, when served with the order, posed for photos with the order and the service boxes, and then taken some time before instructing solicitors. So again, that's context for the
Same night.
content. No, he didn't instruct the surveillance. It's context for the same complaint or unreality response to what is said about forthwith obligation. But my lord, so that there are findings that Mr. Turk, unimpeachable findings that Mr. Turk understood his obligations by the 18th of March at the latest. The 18th of March is a date that this court should have the utmost confidence in, and my overarching submission is this court just should not scrutinise the evidence. Mr. Counsel's submissions were an attempt to re-argue the points that he lost in oral closing below. And they're just pure factual points. He's showing you his favourite documents and then saying the judge should not have made the factual findings that he did. But that's, of course, not the test. The test is, was the judge plainly wrong to reach the factual finding that he did on the material before him? I say squarely not, because as the email from Mr. Shepherd and the events of the return date made clear, Mr. Turk was properly advised by Mr. Shepherd during the short adjournment on the return date. And I'll go to the underlying documents in due course, if I may, but at the return date in the morning, Mr. Shepherd, on behalf of Mr. Turk, was denying that there'd been any breach of any disclosure obligations. He was saying Mr. Turk had complied. And then I highlighted a number of respects in which Mr. Turk's disclosure was seriously lacking. And then after the short adjournment, Mr. Shepherd admitted breach. So
Yes, he said there were some gaps, I think.
well, yeah, he went further than that, because he admitted breach because he was driven to admit breach. He obviously could only admit breach after taking instructions, which he did over the short adjournment. And then in his email, he refers back to it having become clear during that remote meeting over the short adjournment that Mr. Turk did not appear to properly understand his obligations. Mr. Shepherd can only have come to that understanding based on explaining to Mr. Turk what his obligations are. So it's clear that Mr. Shepherd did his job. And this is a rather long prelude to what will be my submissions in relation to the understanding and advice point in due course, but I hope it's helpful. My learned friend's attempt to rely on Jones, as cited and analysed in Kia, is misconceived for a number of reasons, but first among them is The obligation to disclose information forthwith is, as the judge held, and as is common ground, an obligation to disclose as soon as reasonably practicable.
When is that?
Well, it depends. So it depends in every case. It's a highly fact-specific inquiry. When you apply ex parte for a forthwith disclosure order, you do not know by what date it will be reasonably practicable to provide the relevant disclosure. You cannot know that because
That's a bit of a problem though in making the order at all, isn't it?
well, it can be, but it's a forthwith order is enforceable by way of committal because it means you have to act as fast as you reasonably practicably can. And so there is an objectively identifiable date or time by which a diligent respondent with the characteristics of the relevant respondent could have provided the disclosure, and that's the deadline for forthwith disclosure. If that deadline is not met, then there is a breach. As in Jones, there was a breach and a contemptuous breach when the mother failed to
Well,
deliver.
that's relatively straightforward. You've got one single act to do by a specified time at a specified place. But particularly in the case of disclosure orders, I mean, you can well imagine that there's a situation in which the respondent to such an order has got some information at his fingertips, other information you need to check it or look at some documents. Yet more information you may need to ask your bank for duplicate bank statements and so on. So it's not a question of delivering a single package at a single time necessarily.
No, I quite accept that, but you have to do the best you can because the order is expressly to the best of his knowledge and ability. So you start gathering what you can and disclosing what you can, and it would not be a breach of a forthwith obligation to say, although I'm able to ascertain this information, I need first to get bank statements from a bank, and I've requested them on an expedited basis. You would then not be in breach of a forthwith obligation. But that rather makes good the point that a forthwith obligation such as this must be continuing. Or to put it another way, a respondent can't come to court and say, I haven't given compliant disclosure by the date by which a diligent respondent would have done. That's it. The proper analysis of the position where a respondent fails to do what is reasonably practicable in response to a forthwith disclosure obligation is that they are in breach, and subject to the answer to one of the questions Lord Justice Moylan asked, in contemptuous breach from the moment that the date by which a diligent respondent would have done the disclosure passes. And to the extent that they are in contempt, as Mr. Turk was on the findings of the judge below, their contempt may not be properly characterized as a continuing contempt, but it is an unpurged contempt because they failed to disclose information they should have done, placing them in contempt. And the way to purge their contempt is to disclose the information. And if a respondent does not, as at the deadline for forthwith disclosure, understand as fully as they might their disclosure obligations and breaches the obligation, and then an hour or a day later fully understands their obligation, so understands they're in breach, their breach becomes a committable breach if it wasn't before, because they now understand everything, and a respondent behaving properly would say, oh, I'm in contempt, albeit possibly a technical contempt up until the moment that my understanding crystallized. I must purge that contempt. That's the proper way in my submission of analysing Keir and Jones, to which we'll return. And I'll make submissions on the authorities to which my Lord Justice Lewison referred in due course, if I may. But in Solidchenko, one of the cases that we do rely on in the context of sentencing, this court talks about the importance of the coercive element where there is a continuing breach of a disclosure obligation. And that's completely consistent with and reinforces my analysis. The breach ceases to be a continuing breach if you disclose the things that you should have disclosed by the deadline but failed to disclose. That also has the effect of purging what would otherwise be an unpurged contempt.
Speaking for myself, there's a fundamental, as I see it, difference between a continuing obligation and a breach which remains a continuing breach, which you haven't addressed by giving the information or the documents or whatever it might be. But there is a difference, because otherwise you have a rolling analysis. You never know when you're going to stop if it's phrased as a continuing obligation under the terms of the order.
My lord, quite so. So when Mr. Counsel said there should be other words tacked on to the forthwith obligation, he said, or otherwise as soon as reasonably practical, they're just tautologies. One can conceive of it purely in terms of continuing breach, or as I said, unpurged contempt. One does not need it to be a continuing obligation. But however one analyses it, and to an extent it's a semantic question, the matter of policy and principle is a respondent cannot fail to embark on the exercise by the time the forthwith obligation falls to be performed, and then continue to sit on their hands in full knowledge of the fact that they've breached the forthwith obligation. And a fortiori, where, as we'll see from the, sorry, my Lord Justice Lewison has a question.
So let me just see if I've got this right. You say the forthwith obligation is to some extent elastic because nobody knows how long it's going to take for a diligent respondent to provide the information. But what you can say is that the diligent respondent must immediately set about the process of retrieving and disclosing the information.
Absolutely.
But when do you say that Mr. Turk breached paragraph 16? At what date?
By or before the 18th of March, and then again at the 22nd of March, and that's also how the judge analysed it. And the reason
22nd of March was the date for the affidavit.
it was, my lord, but the devil is in the detail, because I agree in general when one construes the order, the affidavit is the cherry on top, because the affidavit isn't actually meant to provide any new information. It's meant to verify as true the information already disclosed. But in this case, something that Mr. Counsel failed to allude to altogether, after Mr. Shepherd admitted breach, he said that he craved an indulgence and an extension of time to produce the affidavit, explicitly on the basis that in the affidavit, Mr. Turk would give the information that was missing. So that was the basis on which he sought and obtained the extension. And that is like, Lord Justice Lewison, I would submit, the example I gave of a respondent who says, I know that the information's in the bank statements, but I need time to get the bank statement. Because Mr. Shepherd is saying to the court, Mr. Turk has not provided forthwith disclosure yet, but he will do so in his affidavit if you grant the extension of time. And that's consistent with Sir Anthony Mann's analysis at paragraph 30 of his judgment, because he accepted my submission that the 22nd of March is the key date. The 22nd of March is the key date because of the events of the 18th of March. But even if, my lords, my lady, were minded to disagree with Sir Anthony Mann in that analysis, the relevant date couldn't be earlier than the 18th of March, and on the 18th of March, Mr. Turk had all the relevant knowledge and understanding.
And that's the judge at paragraphs 267 and 268.
It is. And as I mentioned, my primary submission on this, as on other factual questions, is the court should not go into.
No, I follow.
Yes.
But can I just put this to you? Let it be supposed that on the 11th of March, Mr. Turk did not fully understand what he was supposed to do. But by the 18th of March, after the short adjournment, he did. Is he not then allowed some time to put his understanding into effect?
Well,
By saying, now I realise I've got to disclose all this stuff that I know in my capacity as a director of this, that or the other thing. Some time to go about doing it.
well, on one view, yes, but even if the answer is yes, the time he was given was until the 22nd of March, and then he came up drastically short again with all the knowledge and understanding in the world. But actually, I come back to, and perhaps now is a convenient time to address Lord Justice Moylan's question about the third of the Masry ingredients. So knowledge of the facts that make the act or omission a breach. Mr. Turk knew disclosable information, so the judge found, and also knew the facts that meant that he could access further disclosable information, so the judge found. C.e.g. the SGP bank statements which were in Mr. Turk's email inbox. So even if he didn't know what was in those bank statements, he certainly knew the facts that made it possible for him to obtain the information. So the third Masry ingredient, so when my Lord Justice Moylan said, what does that mean in the specific case? It means exactly what I've just said. Knowledge of information or knowledge of facts that found the ability to obtain information that is disclosable. So Mr. Turk had that knowledge at all times. He had that knowledge from when he was served with the order onwards. So all three Masry ingredients are satisfied. So Mr. Turk was in contemptuous breach long before the 18th of March because he didn't even try, so the judge found. As in didn't even try to comply. And then when one comes to analyse the seriousness, it's appropriate in my submission, and indeed necessary in the interest of justice, to look at the seriousness as at the time when it's clear beyond argument, beyond reasonable doubt, that Mr. Turk understood all his obligations. Because, I say again, a respondent who wants to comply with the court's orders or purge their contempt, once they understand their obligations, discloses the information that they were obliged to disclose. And we'll come back to Jones in due course if we may, but the objection in Jones itself was a very narrow one. It was to it being inappropriate to found a second committal application on the basis of what was said to be a further contempt in continuing not to deliver the child of the respondent. That is absolutely correct. So I could not have brought a committal application against Mr. Turk for one, failing to disclose in accordance with the order, and a separate application for his continuing to fail to disclose. But it's the continuing to fail to disclose that goes to seriousness, as the judge properly understood. Fundamentally, and returning to the reason why in my opening remarks I said all of these grounds can and should be dismissed summarily, ground one raises an interesting point of law regarding intentionality in the context of an omission to disclose. But it does not arise for determination on this case because of the judge's unimpeachable factual finding. The judge held that Mr. Turk understood what he had to do and intentionally didn't do it for the reasons that the judge identified. Mr. Turk's evidence in the witness box is a further reason why Mr. Counsel's submission that it was an inferential finding by the judge is wrong. Mr. Turk said that based on the advice he received from Bavonas, he understood that he had to disclose money movements. That was Mr. Turk's phrase. And that's why Bavonas were asking for bank statements. Money movements is a pretty good proxy for tracing relief, as it's used in here. And the reference to that is in paragraph 40b, little Roman 1 of our written closings, citing the transcript of Mr. Turk's evidence, supplementary bundle, page 576.
Page 576.
Page 576, my lord, yes.
And the paragraph was?
40b, little 1.
Yeah.
Mr. Turk understood before any counsel entered the scene that he needed to disclose money movements. So, as the judge unimpeachably found, he understood the order and intentionally breached it. And so this intentionality question is academic or futile, however interesting it might be. To the extent it assists the court, I also say that Mr. Turk's wrong on the intentionality element for reasons that I can come to if it would assist in due course. Ground 2, I've already really covered, but it fails if ground 1 fails, which ground 1 must fail. It might be useful in performing this somewhat whistle-stop exercise to have the grounds open. They're at page 30 of the core bundle.
Yeah. So this is whether the obligation were continuing.
Yes.
Yeah.
And it just doesn't matter. If ground 1 fails, Mr. Turk must fail on ground 2. And the finding that Mr. Turk had the requisite knowledge as at 18th of March is unassailable.
Well, isn't ground 2, that raises the question of what's the right date to test knowledge, isn't it?
It does, but it can't be earlier than the 18th of March as regards knowledge in relation to seriousness. Even if it's earlier. So I would say Mr. Turk started to commit a contempt as soon as he decided not to embark on the exercise that the order obliged him to embark on. Because a respondent who is acting in accordance with the order starts doing what they can as soon as reasonably practical.
That's what the judge effectively said at 296.
Exactly. So the breach starts then and is perfected at the date by which a diligent respondent would have provided the relevant disclosure. With some of these obligations, as in turning to the specifics of the counts, with some of these obligations, the forthwith obligation, now that we know how complex Mr. Turk's dealings were, may not have been engaged until after the 18th of March, but that doesn't help Mr. Turk because he never gave the disclosure and he had the understanding by the 18th of March. So pushing the forthwith date back doesn't help Mr. Turk, as in later in time doesn't help Mr. Turk, and pushing the forthwith date earlier in time does not help Mr. Turk because the 3 Masri ingredients are satisfied. And then when the court comes to consider seriousness, as Sir Anthony Mann did, Mr. Turk's knowledge by the 18th of March means these breaches were serious and eminently committable. Ground 3 is not pursued. It's wafted by my learned friend in the appeal skeleton and to an extent in his oral submissions in a way that I'm just going to disregard unless it was just the court. It's not pursued as a ground. The judge construed the order correctly, save in the limited respect that is the focus of my cross appeal. I've already explained why there was no procedural unfairness so on ground 4, but my Lord Judge Lewison indicated that the court has read the judgments in full. But might I just invite you either now or subsequently to reread with care paragraphs 9 to 11 of the liability
This is
judgment.
where the judge goes back to the ground rules and says that they were followed and he was satisfied the hearing wasn't unfair and Mr. Turk wasn't disadvantaged.
And the transcript speaks for itself because it's an experience that I've never had before and hope never to have again, where an intermediary was marking my homework constantly, but I was getting passes. And so the intermediary wasn't intervening. Ground 5. This is in relation to the Hawala story. The judge rejected Mr. Turk's very lately articulated Hawala defence as a lie. He was plainly entitled to do so on the evidence before him. This is a ground that challenges an unassailable finding of fact. And
But to what extent was it relevant
Well,
for
it was
him to go into that question?
he did. So I was surprised by Mr. Counsel's submission that the judge shouldn't have embarked on an assessment. It was Mr. Turk who put it in issue. Mr. Turk said, my defence to ground 5 is, and count not, so I'll mix myself up if I call them grounds. My defence to the AET count, which is count 5, and the soft code count, which is count 9, is that they were Hawala payments. And more than that, before I opened the committal application, Mr. Counsel indicated his intention to make a submission of no case to answer on counts 5 and 9 based on the Hawala defence, which I did not begin to understand as a potential submission no case to answer because it rather depended on Mr. Turk's lately dreamed up answer to the case. But he threatened that submission no case to answer. That's how high they put this Hawala defence. So of course I had to deal with it. Of course the judge had to deal with it because it was being said on behalf of Mr. Turk that if the Hawala defence was true, counts 5 and 9 weren't made out or otherwise weren't committable counts. So why did the judge engage with it? Because he had to, because of the defence that Mr. Turk ran. And then I make this submission with some trepidation given that my Lord Justice Lewison every couple of years restates how hesitant people should be to seek to disturb factual findings on appeal, but the test is plainly wrong. So the judge was not plainly wrong. The judge heard cross-examination. He gave a very careful analysis of why the Hawala story was a lie, in his view. If it wasn't a lie, then everything that Mr. Turk had said before about AET and Softco was a lie, which would also be a very serious contempt. And the committal application, and the judge expressly so found, so I believe it was Lord Justice Lewison who asked Mr. Counsel, well, where does this go? It goes nowhere. It's another futile point as well as being a challenge to an unassailable factual finding. Because even if this court concludes that the judge should not have embarked on the assessment, which I say the judge obviously should have done, was bound to do, or that the judge was plainly wrong to reject the Hawala lie, Mr. Turk is hoist on his own petard because he committed the most serious contempt, really equally as serious, by lying until he came up with the Hawala story. And these aren't casual lies, these are things that are put in Mr. Turk's pleading, and things that are put in Mr. Turk's witness evidence and said on his behalf in submission, said by him when I cross-examined him. And I ought just to mention, Mr. Counsel suggested that, well, by the time of the cross-examination hearing, Mr. Turk's focus had rather shifted from compliance with his disclosure obligations. The purpose of the cross-examination hearing was to get Mr. Turk to comply with his disclosure obligations. So that submission does not work. But on Hawala, if you're against me on my primary submission, which is an unassailable factual finding, which the judge was bound to grapple with, then it goes nowhere, because the judge, possibly anticipating this challenge, said, but even if the Hawala story is true, Mr. Turk is in very serious contempt on grounds 5 and 9. Ground 6, this concerns what is said to be Mr. Turk's liability in his capacity as a director. It has two limbs, the procedural and a substantive limb. The procedural limb is this penal notice point. The fatal defects with ground 6A, if I can call it that, the procedural limb of ground 6, are twofold. First, it ignores or mischaracterizes the judge's careful analysis of the penal notice point at paragraphs 64 to 79 of the liability judgment, to which we will go in due course to the extent it would assist. The second fatal defect is it is an attack on an unimpeachable exercise of discretion, because the judge said at paragraph 77, page 173 of the core bundle, that if there was a procedural defect, which there wasn't, he would have exercised his discretion to waive it. Mr. Counsel sought to make 2 points in relation to that. He said, well, there was no application for waiver of a defect. There did not need to be, because the court has an inherent jurisdiction to waive any procedural defect. We did not make an application because we did not consider there had been any procedural defect, and that remains Mrs. İŞBILEN's position. So the lack of an application goes nowhere. And then Mr. Counsel said there was no basis for the judge's finding that Mr. Turk was not prejudiced by any procedural defect. Not so. There was an abundance of evidence to justify that finding, because at every stage, following the return date, at which I was at pains to explain Mr. Turk's obligations by reason of his directorships of SGP and Barton, Mr. Turk purported to give disclosure in those capacities. So he was cross-examined in relation to the disclosure obligations that were unique to SGP and Barton. So long before the 22nd of March, he absolutely understood that he was obliged to give disclosure in his capacity as a director of those companies, whatever that might precisely mean.
Does that matter?
On prejudice, it matters.
I suppose it does on prejudice, yes. It doesn't matter on whether the penal notice was correct or not.
No, I'll address you on that, my lord. But the penal notice absolutely was correct as at the relevant time, and indeed still would be correct now. And the judge's analysis of that was absolutely correct. I really can do no more than walk this court through it.
Well, that's what I'm saying. It was directed at Mr. Turk personally, and what he carried in his head or had access to, irrespective of the capacity in which he carried it in his head or had access to it.
Exactly. And as regards the obligations of Barton and SGP, this is a point my Lord Justice Moylan alluded to, Mr. Turk is liable by reason of his directorship if he failed to take steps that would have caused those companies to comply with those disclosure obligations. I'll come to deal with Tuvalu, which is the second half of ground 6, what I call the substantive ground. His only defence would be if he reasonably believed someone else was doing it, so another officer was causing the company to comply. To make my submission slightly less abstract, imagine a company with 2 directors, A and B, both of whom know piece of information X that is disclosable. It's a bit like that Roman law problem of the 2 marksmen and the body that's found with an arrow in it. Both could potentially get off a committal application by saying, I reasonably believe that the other director was going to cause the company to disclose a piece of information X. Mr. Turk cannot, on the factual findings of the judge, avail himself of that defence in relation to either SGP or Barton. Because as regards Barton, Mr. Turk said in his evidence he was the only person who knew the relevant information. And as regards SGP, the bank statements that contained the relevant information were in Mr. Turk's inbox, email inbox, and no one else's. So he didn't have any prospect of a reasonable belief defence, if I can refer to it in that way. And that really leads to the short and dispositive answer to ground 6b, which is whilst the judge did not refer in terms to Tuvalu, we did in our written closing. We explained the principle to him, and I'll show the court that in due course. And then he clearly had it in mind when he came to consider the position in relation to Barton and the position in relation to SGP, as I've just explained.
But just go back a moment to how this interacts with the penal notice. And let's take paragraph 15 of the order, which is the freezing order.
Yes.
So the two companies are ordered not to dispose of assets. And let's suppose they do. So it is they who dispose of the assets, not any individual. Obviously, they can only act through the medium of individuals, but it's the companies themselves who do it. Granted that Tuvalu says the director has a duty to take reasonable steps to ensure compliance, but in those circumstances, in order to make the director vicariously liable for the company's breach, you would certainly need a penal notice to say so, wouldn't you?
Well, vicariously liable possibly, but directly liable. Two answers. If the director was named on the order elsewhere, then on the authorities as they stood at the time Mr. Justice Miles made his order, that would be sufficient as a matter of procedure, and I'll endeavour to show my lord that in due course. But even if that were wrong, then it would be the sort of procedural defect that might readily be waived by a judge in the exercise of their discretion. And when one talks about vicarious liability, when I was last in this room 2 weeks ago, I was talking about vicarious liability in a very different context. Vicarious liability in the context of seeking to commit someone for contempt is a distinct concept from vicarious liability when one's looking at civil liability properly so called. So a director can be not vicariously but directly liable for contempt if they know the order and intentionally cause the company to breach the order.
And then the question would be, did the penal notice warn them of that possible consequence? And if it didn't, is it right to waive the failure?
And that would all be a highly fact-sensitive inquiry. But here,
the judge essentially based himself on the fact that paragraph 16 was directed to Mr. Turk himself.
Yes.
I won't use the adjective personally because that's confusing, but he was required to make disclosure of what he knew. And the judge said, well, it doesn't matter in what capacity he knew it. If you've got knowledge, you've got knowledge.
Exactly. Well, that is right. And then as regards the paragraph 16 obligation, which is an obligation that Barton owed, Mr. Turk, coming back to the Masry ingredients, knew that he was the only person who could cause Barton to comply, knew information that was disclosable and failed to disclose it, therefore was in contempt of contemptuous breach of paragraph 16, and that contemptuous breach was serious and committable as soon as Mr. Turk understood that he was obliged to give the disclosure, which he did by no later than the 18th of March.
So as I understand it, you were seeking committal on the basis of corporate failure. So in other words, the failure of the companies to comply with their obligations under the order.
On both bases, my lord. So on the basis that it was yes.
But it included that.
That was the reason for the words "and or" to which my Lord Justice Moylan referred in the
So which grounds referred to only the latter?
Oh, so the Barton ground. I'll have to come back.
Don't worry.
We're concerned only at all with the Barton and SGP grounds because those are the only companies of which Mr. Turk was relevantly a director, as in relevant to the obligations of those companies under the order. And if I might just let Junior Mr. Gurd check the application notice while I continue to address the court, I'll clarify whether in respect of either we relied solely liability
So
quadrilateral.
it was that he was liable for the failures, the company's failures, respectively, to comply with their obligations under the order.
So this is where I parted ways very modestly from Lord Justice Lewison in his use of the term vicarious liability. It's not that Mr. Turk was liable for the company's non-disclosures. It's that fact A, the company did not disclose information. Fact B, Mr. Turk was a director. Fact C, Mr. Turk knew the disclosable information or had the ability to obtain it. Fact D, he did not have the reasonable belief defence to which I've alluded, as in the reasonable belief that any other director could cause the company to give the disclosure. And then fact E, by no later than March 18th, Mr. Turk understood that both himself and on behalf of the company, he was required to disclose this information. And so that made his contemptuous breaches serious and committable. So those are the facts that led to his liability in respect of these two grounds.
Yes, my reading of the application notice, page 264 of the bundle, is that the allegations were directed against Mr. Turk and Mr. Turk alone.
Yes, absolutely.
And he was the subject, as the judge said, of the disclosure order. So the disclosure required was what happened to the money that Miss İŞBILEN entrusted to you to manage. And if Mr. Turk knew that a payment had been made to Company A, and that Company A had then made a payment to Company B, those were facts which he knew.
Absolutely.
And it doesn't really matter whether he knew about the transfer between A and B because he was a director of A or B or both. He knew it.
Yes. My Lord, I'm not seeking to argue against myself. I am seeking to be precise about what the judge found and to meet the challenge.
If that analysis is right, and I think Mr. Counsel says it's not, but if it's right, then Tuvalu's got nothing to do with it.
Well, Tuvalu does on paragraph 16 of the 17 of the Miles order, my Lord. Sorry, if you might turn that up in the supplementary bundle.
Well, I'm looking at it on page 239 of the core bundle,
Oh, yes.
and it's quoted, on service of this order, the first, that is Mr. Turk, must inform.
It's paragraph 17, my Lord.
17. Right. Yes, I see.
And then, my Lord, I'm afraid I lost track of whether it was my Lord Justice Lewison or Lord Justice Moylan who raised the question or expressed their understanding of how the application was put. I think it was Lord Justice Lewison. The application is put as it's put in the application notice and then explained further in the document that Sir Anthony Mann directed us to produce following the CMC. And both the application notice properly construed and the subsequent explanatory document made clear that we were seeking to commit Mr. Turk for all of the things that he knew himself and was obliged himself to disclose. And then also on the ground that, as regards obligations of Barton and SGP, he and he alone knew disclosable information and deliberately failed to disclose it.
Right. So it goes to breach of paragraph 17.
Yes.
Yeah.
That's in respect to Barton, isn't it? Which is 17 Barton or is 17?
17's Barton.
So which is is SGP?
SGP, my Lord.
Which paragraph is that?
Yes, that's why I initially said paragraph 16 in relation to Barton. So paragraph 16 is SGP, paragraph 17 is Barton. Barton was, to all intents and purposes, Mr. Turk. Mr. Turk was its owner, Mr. Turk was its director, Mr. Turk was the signatory in all the accounts, Mr. Turk controlled all the money movements. He gave evidence to that effect. And on my Lord Justice Lewison's question about prejudice, Mr. Turk very well understood that the disclosure obligations bit on his knowledge in relation to Barton.
Yeah.
And so the judge found.
Right.
So this is again, this 6B ground, the substantive aspect, is both stymied by unassailable factual findings and ignores the judgment, the terms of the judgment. It is at its highest a complaint that the judge did not explicitly refer to Tuvalu, but as has been made clear repeatedly at the highest level, judges don't need to deal with every argument explicitly before them, but Sir Anthony Mann did deal with the substance of the Tuvalu point in making the findings that he did in relation to Barton and SGP. There was no other reason for him to do so. Ground 7, which is about the failure to adjourn and coupled to it the finding of harm.
I thought you were going to deal further with the penal notice.
Oh, I was, my lord, I was cantering through the grounds to explain why I say they should all be summarily dismissed, and then I will elaborate to the extent necessary if that would assist. I will of course give the penal notice the attention that it warrants, my lord. So, ground 7, the failure to adjourn goes nowhere, but was obviously an unimpeachable exercise of discretion. I would submit, although I need not begin to persuade you of this, that the judge would have been plainly wrong to adjourn. Another lack of reality to my learned friend's case is that he says the question of whether the AET and Softco transactions were Hawala payments needs to be determined at trial. Not on the pleadings. On the pleadings, Mr. Turk still hasn't amended. I know he's acting in person now, but he was represented for a very long time. And on the pleadings, Mr. Turk's case is still legitimate transactions. Look at these invoices that he merrily said before Sir Anthony Mann were shams. There is not a pleaded issue that requires determination at trial. And Sir Anthony Mann, having embarked on the assessment that Mr. Turk's defence required him to undertake, i.e., is my Hawala story true, and resolved it against Mr. Turk, obviously should not then have adjourned sanction for a trial at which the Hawala story was not pleaded.
And what's your answer to Lady Justice Laing's question to Mr. Counsel about the status of the finding made by the judge?
It's not binding.
It's not binding.
It's not binding because there will be disclosure and other evidence at the main trial. Is that if Mr. Turk might be well advised not to try to resurrect or plead the Hawala lie, but he could do so. He'd have to seek to do so by way of amendment, and we'd be perfectly entitled to oppose that amendment application on the basis that there was no real prospect of success. But I wouldn't be relying on Sir Anthony Mann's findings in opposing that amendment application. I'd be relying on all the forensic points that I relied on.
Why is it not an issue, Stolpen? Is it because it wasn't necessary for the determination, or what?
So it wasn't necessary for the determination of the
Committal application.
the liability questions. It only comes into seriousness. So I think for that reason, it does not give rise to a true issue estoppel. And then the other reason that came to mind was, as I just alluded to, not all of the material and not all of the evidence that will be before them.
It wouldn't be an abuse as a collateral attack.
It might well be. I mean, that's a point that I might be making if Mr. Turk sought to introduce this by way of amendment, which would be the only way he could get it in. So this is not a real world where Mr. Turk seeks to amend to introduce a story that's been found beyond reasonable doubt to be a lie, and I unsuccessfully oppose that amendment, and then there's a trial. I'm sure I'll be trying to say it's an abusive process, and I don't want to be bound, issue a stop from saying there's an issue of estoppel. But,
I'm just exploring the question.
no, of course, but my instinctive view, having only had the shorter gentleman think about it, is there isn't a true issue of estoppel. He's not bound by it. But in any event, it's not an issue on the pleading.
Yeah, well, that I had appreciated from the skeleton.
And harm, there is an abundance of harm. This is a misconceived point that Mr. Turk has been trotting out since the opening of the committal application. No harm unless the underlying claims are proved or unless Mrs. İŞBILEN's version of events is accepted. That is categorically wrong. If that were right, then whenever there was a committal application in relation to ancillary disclosure obligations, one would have to kick off sanction until after trial. The harm comes, as explained in Novan's Jets, to which we'll come probably later this afternoon. The harm is crystallized and substantial when a respondent fails to do the thing they're obliged to do, leaving the applicant with gaps and leaving the court with gaps. And in this case, Mrs. İŞBILEN did not bring a committal application as a first resort. She truly brought it as a last resort because she took so many steps to try to get the missing disclosure, including ultimately obtaining a search and imaging order.
Well, I mean, there are two aspects here on there, it seems to me. One is the submission that, oh, well, she authorised all this, and therefore I'm not liable in the underlying action.
Yes.
And I see your point that, you know, that's got to wait until the main action's tried, and there's not a reason to defer sanction. But the other point, which is a different point, is, well, she already knew all this. She knew where these assets were, and therefore I didn't think I had to tell her. That's a different point, which I think is partly what Mr. Counsel was saying, or Mr. Turk was saying. I didn't think I had to disclose this information because I thought that Mrs. İŞBILEN knew it already.
That was only in relation to the Hawala lie. So, because the other information, there was no suggestion, for example, that Mrs. İŞBILEN knew all of the steps in the trail. Even where Mr. Turk says, "Oh yes, Mrs. İŞBILEN authorised the initial payment to the fund the so-called fund I established in the Cayman Islands," there was no suggestion that Mrs. İŞBILEN then knew about the onward movements. Right? So it's only on Hawala. If I'm right in my rebuttal of ground 5, this question just doesn't arise because the Hawala story was found by the judge to be a lie, which means that necessarily Mrs. İŞBILEN did not know where the money went, and so was caused very substantial harm by the non-disclosures in relation to AET and Softco. Now, if Mrs. İŞBILEN did know the Hawala, so if my lord and my lady are against me on ground 5, and to such an extent that you conclude that the judge was plainly wrong not to accept the Hawala story as true, then there'd be an argument on harm. Mm. But I would say it would be entirely wrong to go that far. It would be entirely wrong to interfere with the judge's factual finding at all. But the reason why Mr. Turk is between a rock and a hard place on AET and Softco is, even if he wasn't lying about Hawala, he should have said it from the very start. He should have said, what are these claims about? Mrs. İŞBILEN knows well. She authorised these as Hawala payments, and she knows everything, because he was saying in the witness box in this committal application, for the very first time, Mr. İŞBILEN gave me a list of ultimate recipients. But he didn't have that list to disclose. And if that had been true, that would have been disclosure that he should have given immediately. And at no point was that his response. To the contrary, his response was, as Mrs. İŞBILEN well knows, these were bona fide transactions that reflected exactly the invoices that I am disclosing.
Yeah.
So yes.
Right, that's ground 7.
And then grounds 8 to 11, just in drastic summary, obviously will go to sanction. And in my submission, they all fall into the misconceived challenges as to exercise of discretion. And of course, I say that in one respect on sentencing, the judge.
Yeah, why was there no coercive element involved?
Why was there none?
Why was there none? Why did the judge say this is purely punitive?
Well, that's the subject of my cross appeal
Well,
on.
I follow, but if it's right, if that point's right, then isn't that quite a powerful factor in favour of suspension?
No, my lord, because Mr. Turk, and I made this point at the sanction hearing, Mr. Turk apologised, but did not say, and here's all the information that I should have disclosed, or I promise I will now provide all the information.
Yes, I think the judge does make that point.
And my lord, Mr. Turk's evidence was, now Janes have explained it to me, I understand with crystal clarity everything I'm obliged to have done.
Paragraph 16F on page 254, he deals with that point.
Yes, so, and this is a point that I made an argument at the sanctions hearing, if you were to suspend the sentence in a way that had meaning, in the sense that the suspension could be triggered to end, it would immediately end. Because it would be suspended on the basis that if Mr. Turk complied with all the obligations he's in breach of, still, well and good. But if he failed to do so, then the sentence would cease to be cease to be suspended, and Mr. Turk would be imprisoned immediately.
But if he's imprisoned immediately, presumably it is open to him to apply to purge his contempt by providing the disclosure, the missing disclosure.
Exactly. That's the way, and so, my lord, that's, in my submission, say that there are stages to the argument. But first, where you have a respondent who says he understands everything, who the judge has found understands everything, who's in continuing breach, to use my lord Justice Moylan's preferred terminology, and is not saying, and I'm going to do my best to remedy that breach now, suspension is completely inappropriate, because you have a respondent who is in unpurged contempt.
So in other words, if he's not saying, please suspend the sentence subject to a condition requiring me to comply, if he doesn't say that, then why should there be a coercive element? There's no point. Is that
No, so that shouldn't, there's absolutely no basis for suspension unless there is some prospect of him doing the things that he has so far failed to do. And there is none, because he's still not saying, I'll try to do it. And even if he did say, this is a further point that I made to Sir Anthony Mann, even if he did say, I will now try and do it, there'd be no way for the court or Mrs. İŞBILEN to ascertain whether he actually had done it, because he knows all the information and we don't. So he could just give some further bits of information, but the judge has held that he's a liar and that he's deliberately non-disclosed. So suspension of the submission that in this sort of case, suspension should be the default. It is, I would suggest, deeply problematic as a matter of policy and principle. You've got a respondent who deliberately breaches their disclosure obligations, and I say, and this is the subject of the cross appeal on sentencing, absolutely you should have an element, a coercive element in the sentence where there are continuing breaches, unpurged contempts, and then they, one would hope, will incentivise the contemptor to purge, and then on purging they can apply and say, I'd like my sentence reduced, or I'd like my sentence discharged even, because I've now purged my contempt. That's the way this should, in my submission, work. If you do it as my learned friend urges, then the contemptor gets off scot-free. And it is scot-free because it's a suspension that only ceases if a new contempt is proved. And this case has made clear how difficult and costly it can be to prove contempts. And it's not just an applicant who is interested in ensuring that a court's orders are complied with. It is first and foremost the court and the public.
And I suppose you can contrast the obvious case where somebody's required, say they're in breach of planning control, they're required to pull down a building. You could suspend on the basis that if you pull down the building within the next 6 months, we'll suspend for 6 months and see what happens.
Absolutely.
And if you pull down the building, fine, and if you don't, the sentence kicks in.
Exactly so, my lady. Or a respondent to a freezing injunction who's put money out of reach, you could suspend and say, if
Give it
you...
back.
Yeah.
That's not this case, because you have what is still, although he's saying he's sorry, he's still a defiant, non-compliant respondent. That's the proper way of characterising him.
Could you not draw up a list from the judgment of what the judge has found he could have done but hasn't done?
My lord, not with anything like sufficient comprehensiveness or specificity to be enforceable, because we are still, a point that I made repeatedly below is, one needs to see the wood for the trees here, because we had to focus on individual contempts that we could prove, where we'd ascertained via the search order, for example, that there was a piece of information that Mr. Turk knew but had failed to disclose, even though it was disclosable. But there is a universe of information which we do not know, and Mr. Turk does know. And we have no idea what the limits of that universe are. So we cannot draw up a shopping list by reference to which Mr. Turk could purge his contempt, or by reference to which a sentence could sensibly be suspended. If Mr. Turk, I said this below, I'll say it again here. If Mr. Turk wants to start making meaningful efforts to disclose what he should disclose, we would of course welcome them. But that's the way to approach this, not default suspension of sentence. And my lord, his obligations...
Well, that makes purging his contempt more difficult, doesn't it? Because if, as you say, you have no idea of knowing whether he has or he hasn't purged his contempt, how does the court?
Well, my lord, that might be, although it wasn't expressed to be, a reason why Sir Anthony Mann did not include a coercive element. That might be why, because otherwise I struggle to see a reason for it. But if he provided us information and then an explanation of why he couldn't provide us any more, then we'd obviously take a view. And he could apply to court on the basis that he'd purged his contempt.
Yeah.
And he'd bear the burden of saying, this is the most that I know, because he's not obliged to disclose perfect information. He's obliged to disclose what he knows and is able to disclose. And if, when we're looking at the metaphors we use, the last step on the trail or the last link in the chain, if he says, I didn't tell you before, but this is the last link in the chain that I know about, and I don't know what the next link is because ... then we would obviously take a view, and if we thought that was not adequate, the court might disagree and consider that he had purged his contempt.
Yeah.
That's the way this works. These are extremely serious contempts that the judge found, and they are aggravated most significantly by the lies that Mr. Turk told in relation to Softco and AET, but also by the very substantial harm that he caused Mrs. İŞBILEN and the administration of justice, and the waste of court resources and Mrs. İŞBILEN's resources involved in all of the steps that we have taken in seeking to get the information he should have disclosed in the first place. And yet, my learned friend Mr. Counsel says, oh, well, given the state of the prisons and given the condition of Mr. Turk's mother, he should have had a suspended sentence. Suspended sentence would achieve nothing in this case. But again, I do not need to persuade this court that the judge was right to exercise his discretion as to sanction in the way that he did. I only need to satisfy you that he was not plainly wrong. And I say he was amply justified. And the discount that he allowed in respect of Mr. Turk's mother, I would suggest was extremely clement. It was very far from perversely merciless. So, that is my canter through the grounds. And I was then going to turn to ground one in detail, if that would assist. As you'll appreciate, the headline point is that having belatedly conceded all the money flows, and necessarily, therefore, after either losing or abandoning construction points, admitted the three Masri ingredients, subject only to Moylan and Friends' intentionality point. The main plank of Mr. Turk's defence was a failure to understand. And the failure to understand defence, in respect of which he bore the evidential burden, was rejected by the judge. Given Moylan and Friends' reliance on what was said at the return date, it might be helpful to spend a little time looking at the transcript of that hearing, which is in the supplemental, as in the bundle that was lately provided.
The one we got this morning. I thought I'd seen a transcript of.
Sorry, it's a supplementary bundle.
I thought I'd seen a
in the
transcript of that hearing before.
I was wrong, my lord. It's in the supplementary bundle at tab 37, and I wanted to go to page 103.
Tab
37, my lord.
Oh, I actually haven't got tabs. What page is it?
Page 1039. Starts at 984, and hopefully,
Yes.
if you'd please take it up at 1039. At line 10. And just invite you to read page 1039, line 10 through to line 15. And then you'll see after the submission was that the obligation has not actually fallen due yet for compliance. And then Pat Tracy, sitting as a Deputy High Court Judge, said that is the obligation to give the affidavit, yes. That was due the following day. And then if I might invite you to read on. This is the submission I paraphrased in response to a question from my Lord Justice Lewison earlier, where Mr. Shepherd was saying, as you'll see, that he's making submissions as to how things usually work. There's informal provision of information, and then subsequent confirmation or clarification or addition, he suggests. And then at the bottom of that page, you'll see that the affidavit is presented by Mr. Shepherd as an opportunity to remedy any of the deficiencies such as they are that my learned friend has identified.
Yeah.
Unless it will assist, I need not show you all the places where I identified them, but I sort of highlight all the major deficiencies. And immediately following on from that is Mr. Shepherd's application for a short extension of time.
Yeah.
And so this was where what was being said following the meeting, the conference over the short adjournment, was that Mr. Turk, there were deficiencies in Mr. Turk's disclosure and an indulgence was being craved. It is, in my submission, absurd to suggest.
Sorry, which bit are you looking at?
It's the admission of deficiencies such as they are, and then I will come to give you a couple of further references in a moment, my lord. But the headline point is that Mr. Shepherd was saying on behalf of Mr. Turk, please give Mr. Turk more time.
Yes.
And yet now Mr. Turk is saying, in assessing the seriousness of my non-compliance, disregard the perfect understanding or the sufficiently adequate understanding that the judge says I formed on precisely this day. My lord, returning to ground one, I'll give you those references in a moment if I may, but returning to ground one, at page 30 of the core bundle, the submissions or the contentions that the judge failed to apply the criminal standard of proof and somehow reversed the burden of proof are not pursued. It seems, certainly the suggestion that there was a reversal of the burden of proof was only in the original grounds and not in the perfected grounds. But as regards ground 1C, which is said to be the judge's failure to apply the criminal standard, the judge explicitly did apply the criminal standard. That is at paragraph 286 of the liability judgment. So that ground simply falls away.
And that's not the only place he applies the criminal standard. There are
No.
references.
No, of course, no, but this is the complaint. It's tied to
Yeah.
this advice question, my lady, and he explicitly applies the correct standard
To that question.
to that question.
Yeah.
And then 1D, in substance, seeks a retrial on the papers of Mr. Turk's defence that he was not properly advised. As I've said already, there's no basis for challenging the judge's meticulous findings on that issue. They are at paragraph 243 to 286 of the judgment. And in any event, the advice question is in some ways a distraction given the finding that Mr. Turk himself was capable of understanding the order. It's not about advice. Advice was a defence raised by Mr. Turk, and to the extent it was a red herring,
Yeah.
It was dispatched by the judge. And the appellant accepts that the judge correctly directed himself. That's their appeal skeleton at paragraph 27, the acceptance that he correctly directed himself. And there is no failure to draw proper inferences alleged other than in relation to the advice question. So there are these complaints about not applying the correct standard of proof, what he did, and then a generic complaint about failure to draw proper inferences, but the complaint is only about the advice question. And on the advice question, to the extent that any finding is properly characterised as inferential, the inferences were plainly open to the judge on the material before him. I don't know in what form my lords, my lady, have our skeleton, whether it's just in the court bundle, whether you have it loose, but at paragraph 25 of our skeleton, we identify the three grounds for the factual challenge on the advice question.
Sorry, your skeleton.
Our skeleton, paragraph 25.
Yeah.
So we identify the three grounds of challenge. If I might just invite you to reread those. And then the answers to those three grounds are given immediately below. But in a nutshell, the judge was perfectly entitled to conclude that advice had been given. Indeed, in my submission, the contemporaneous documents really mandated that conclusion, in particular the Shepherd email, the transcript of the return date, and then critically, the events to which the judge referred after the 18th of March, so this is when Mr. Quirk KC came on the scene. There was ample basis for the judge to conclude that advice had been given and to draw that conclusion up to the requisite standard. The assumption that advice was received, as in advice was properly given by specialist solicitors and barristers, is not an assumption that the judge applied rigidly or inflexibly. He just said that was his starting point, and it was treated by him as both plastic and rebuttable. And that again is entirely reasonable. Tribunals of fact start by considering inherent probabilities. It's inherently probable that a specialist firm of fraud solicitors and two specialist counsel, including leading counsel, will advise a respondent properly in relation to their disclosure obligations, a fortiori where it is said by the claimant applicant that the respondent is in serious breach of those disclosure obligations. That's an assumption he was entirely entitled to start with. And as emerged during exchanges with my learned friend, Mr. Counsel, the decision to waive privilege was expressly considered by the judge at paragraph 286 of the judgment. It was reasonable to give little weight to it, given its timing and given its unsatisfactory nature, but also given, my learned friend suggests that the only inference from Mr. Turk's waiver, very belated waiver of privilege, is that Mr. Turk was not properly advised. Well, no. Two other explanations are he was just running a defence recklessly or desperately, or he was running a defence having forgotten the advice that he received and maybe even genuinely believing that he had not been properly advised. Although, as I said in his original witness statement, he just said he couldn't recall being properly advised, and that then hardened. That might be a manifestation of the tendency to have a self-enhancing memory. He wanted to come up with an explanation for why he didn't comply, and he eventually may have persuaded himself that he was not properly advised. That's a perfectly credible explanation for his waiver, but it's very far from the case that the only inference where a respondent waives privilege is that they must not have been properly advised. The judge did not act in a way that was plainly wrong in giving.
Well, the submission wasn't that the waiver of privilege shows that he wasn't properly advised. It's the waiver of privilege plus the contents of what was revealed by the waiver show that he wasn't properly advised. That's the argument.
Well, my lord, I'll meet that argument, but the submission that I can refer to the transcript tomorrow if I need to. Mr. Counsel did make the submission that the only inference from the waiver was that the defence was good, and I say that's not a good submission. And then to the extent that he's relying on the inference plus the documents, I say the documents do not help Mr. Turk. They inculpate him because of the judge's careful analysis, which was plainly open to him, and critically because of the letter attaching the order, a subsequent email from Mr. Bachelet highlighting only the disclosure obligations to which the judge referred. That predates the return date. And I asked Mr. Turk a series of questions about that, but in essence, it's very strongly suggestive of a solicitor drawing disclosure obligations to their client's attention. It'd be odd to send an order with disclosure obligations circled and then give no advice about them at all. And then we have on Mr. Turk's case, scales falling from the eyes on the 18th of March, because he's messaging Mr. Bachelet saying what we haven't complied, and then the advice from Mr. Shepherd. The email properly construed, and my Lord Justice Lewison indicated that he'd read Mr. Shepherd's email. I would invite the court to reread it if time allows. The proper construction of that email, a sensible reading of that email, is the reading the judge adopted, which is that Mr. Shepherd had given proper advice. And then Mr. Counsel really entirely glossed over everything that happened subsequently, where there was the schedule of compliance, or it would be better called a schedule of non-compliance, produced by Mr. Shepherd, that became a working document that Mr. Quirk-Casey used as the framework for a very long video conference with Mr. Turk on the Sunday before the adjourned return date. And I said below and will say again, the idea that in that context, Mr. Turk was not properly advised is fanciful. It can be rejected without any doubt, as the judge rejected it. And the question for this court is whether he was just entitled to do so, not whether this court would similarly have done so.
Does it matter when Mr. Turk was properly advised?
Well, the judge held on the 18th, by the 18th of March.
But Mr. Quirk hadn't been instructed.
No,
had he?
the judge held by the 18th of March, a fortiori by the 22nd of March,
Yeah.
and agreed to my submission the 22nd of March was the critical date. But I say there's no way to go behind the judge's finding as regards the 18th of March, and the inquiry for this court should, with respect, stop there. But if this court thinks the judge was plainly wrong to hold that he was properly advised by the 18th of March, the 22nd of March is still early enough for the breaches which were contemptuous before the 22nd of March and the breaches which were contemptuous only as at the 22nd of March to become serious enough to be punishable by way of committal. And that's the judge's analysis.
So the breach which wasn't serious at the time it was committed becomes serious by reason of later events.
Becomes committable. Because, and my lord, that's absolutely the point. That's how I say that the correct way of analysing this question of sanction and reconciling it with the Masry ingredients. The Masry ingredients are only about whether a contempt was committed, not whether it's punishable by way of committal. And so you have a contempt in respect of a forthwith disclosure obligation at the time when a diligent respondent in the circumstances of the relevant respondent would have provided the relevant disclosure. And I need not satisfy this court and did not need to satisfy Sir Anthony Mann of precisely when that was for any obligation, because for all of the counts, Mr. Turk simply never gave the disclosure. But whether you say that the deadline fell before the 18th of March or after the 18th of March, between the 18th of March and the 22nd of March, or after the 22nd of March, it does not matter, because from the 18th of March, Mr. Turk, at the very latest, Mr. Turk had a sufficient understanding to make all of the breaches that the judge held to be proved sufficiently serious to be punishable by way of committal. It is wholly artificial and entirely contrary to principle to say a respondent can breach an obligation to do something by a particular time and then should not be punished by way of committal, even if a minute later they realise that they're in contempt and do nothing at all to purge their contempt. It is absurd. So on timing, primary submission is should not disturb the judge's finding, but secondary submission is even if you do 22nd of March as the backstop date and still amply justifies committal. So the court should, in my submission, resist the appellant's invitation to put the underlying evidence under the microscope. That's just not the task of this court. But if you are against me on that, we deal with the evidence in paragraph 27 of our skeleton in detail. And that shows, I mean, I'm not going to take you to Foxworth Industries, but we're just looking for a maintainable basis for the judge's factual findings, and that maintainable basis is amply apparent in the facts and matters referred to in paragraph 27. I see the time, my lords, my lady. I was only going to deal briefly with what I've said is the academic question raised by grounds 1A and 1B. You have my submission that Farnsworth adds nothing to Masri. It's consistent with Masri. It's not a new test. It says absolutely nothing about what inadvertence means in relation to breaches by omission. And it is, as I say, an interesting academic point, but on the facts found by the judge, it is only that. And so, if I might invite the court to reread paragraphs 30 to 35 of our skeleton, some of which I've already foreshadowed. And then if that would be a convenient moment, I'm on course to finish by 11:30 tomorrow as planned. Unless there are any points arising. Oh, I promised you references to the return date transcript. So tab 37, we're in page 1042. Lines 3 to 8 and 30 to 34.
Sorry, it's there. Yes.
Sorry, what's the
Yes, that's where Mr. Shepherd accepts that there hasn't been disclosure.
And then at 1049, line 18, I characterised that as admitted breaches and was not contradicted, and that was plainly the basis on which the judge approached the question of extension. And you will have seen alluded to in our skeleton, the judge's observation was Mr. Shepherd submitted that Mr. Turk had had his mind focused by my submissions, and the judge said, how much more focused did he need than a penal notice?
Yes.
Is that a convenient?
Right. Thank you very much. We'll stop there. Do 10:30 tomorrow.
Court road,